Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. So right off the bat, the first trial for Stephan Sterns has been continued. The defense team told the judge today that they were not sufficiently prepared. Not a shock after all the motions that they dropped earlier this month. And we are now looking at April 23rd for a pretrial and early May for the actual trial. So again, we're on a hold, and it didn't surprise me. Like I said, it's basically been a year at this point, so that's probably going to push his murder trial till potentially 2026, but we'll see. I want to play a video and go through some of the motions, specifically about the whole cell phone motions that they filed, and they are trying to suppress, his legal team is trying to suppress the cell phone data, stating that he did not give them permission. And we have all heard the interviews. You've heard him here on this channel. You might have heard him on the news, other channels, that Stephan was specifically asked if it was okay if they took his cell phone. And he said, okay. She even stated, the detective stated, do I need a warrant? And he said, no, that's fine. So he handed it over freely. Of course, now his defense attorney is stating that he was on medication and was not sufficiently in his right mind. Yeah.
The man accused of murdering 13-year-old Madeline Soto is getting ready for his trial.
Stephan Sterns' attorneys are asking a judge to throw out evidence that investigators found on his cell phone and an online account. West 2's Spencer Tracy explains why Sterns believes he had no choice but to hand over his phone.
Sterns claims he had no choice but to hand over his phone. His attorney also says he was under the influence of a prescription anxiety drug that day as well.
I am going to hold on to your phone, okay? I'll give it back to you when we're done. Okay? Do you have any questions for us?
How long are you going to need my phone?
On February 27, 2024, the day after Madeline Soto's mom reported the teen missing, this is the recording of a detective asking Sterns if she could take a photograph of his cell phone history and check the phone's settings.
Your phone. I told you that I was going to hold on to it and that we would like to download your phone, right?
Okay.
Is this something that I have your consent to do, or do I need to get a search warrant for your phone?
It should be fine.
He says it very clearly to me. It should be fine. So he gave them consent to download his cell phone data. See, what I think is, he thought when he was clearing this phone, doing this alleged factory reset, and all this other garbage that he was doing, I think he thought he was outsmarting law enforcement. And he most definitely was not. There are experts that know what they're looking at, and they can retrieve quite a lot of stuff. And just because you think you deleted it doesn't mean it's truly gone.
Investigators say they found hundreds of pictures and videos on his phone that showed him molesting her for years. In a new court filing, Sterns' attorney has filed a motion to suppress that evidence. His attorney argues that it was unlawfully taken and that investigators did not get a warrant to search his phone.
What this is the defense's attempt to try to eliminate or suppress evidence in the trial or trials that the state can try to prove.
As the case prepares to head to trial, the state has not yet responded to this motion in court.
The lawyers are working, the defense is working, the state's working, and, it's designed to sort of vary what evidence would be admissible and what evidence would not be admissible in the trial.
Sterns' pretrial is scheduled for tomorrow. Of course, we'll be there and bringing the latest on air and online.
And I agree that they're going to try to do any and everything possible to defend him. I don't agree, and I couldn't do it, but this attorney, that's their job. So again, we did glance through all of these motions, okay? So there is a lot of them. I believe it's like 300 and something pages. And again, I'm going to go through them, not all tonight. I do want to go through the motions to suppress the evidence from the cell phone and the Google search warrant. Those are the ones I'm going to go through on this particular video, and then I will continue to go through the rest of the motions, because I am sure the filings will continue. But real quickly, for those curious, this is the updated events for 2025, which is actually 2 days before my birthday. He's going to pretrial. And 5/5, 9 a.m., that is when currently his trial for all the sexual images is set. So let's hope that they can retain this May date. I don't see why they couldn't, but you never know. So let me pull up the first one here. So this one here is this is filed again. Most of these were filed, I think, on the 6th, maybe the 5th as well, but they were all filed at the beginning of February. We have all gotten used to reading a lot of these motions and what have you. State of Florida, obviously, versus Stephan Michael Sterns. Motion to suppress evidence obtained from unlawful seizure of cell phone. Comes now the defendant, Stephan Michael Sterns, by and through his undersigned counsel, pursuant to the 4th Amendment to the United States Constitution, Article 1, Section 12 of the Florida Constitution, and Florida Rule of Criminal Procedure 3.190, and hereby moves the Honorable Court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states, and I think this one's going to get knocked down pretty easily, but again, I'm not an attorney and I don't play one on YouTube or anywhere. This case presents a flagrant violation of Mr. Sterns' constitutional rights under the 4th Amendment in Article 1, Section 12 of the Florida Constitution. Detective Tackler with the Orange County Sheriff's Office unilaterally seized Mr. Sterns' cell phone without consent, without a warrant, and without exigent circumstances. I think we all heard him very clearly give her permission, but again, they're trying. The phone was then retained for over 9.5 hours before law enforcement coerced a purported consent for his forensic examination. Because this seizure was unlawful and all evidence obtained bears the taint of this initial illegality, the court should suppress the cell phone evidence and all derivative fruits. The motion is filed compensatorily with related motions to suppress evidence obtained from the unlawful search of Mr. Sterns' phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. Evidence to be suppressed: any and all tangible or intangible evidence obtained contemporaneously. I'm telling you, these words are going to get me going over here. To and following the illegal seizure of Stephan Michael Sterns' cell phone, specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. Standing. Stephan Michael Sterns has standing under the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution, as he was the owner and possessor of the cell phone that was illegally seized on February 27 through 28, 2024. Riley v. California establishes these cell phones are entitled to heightened Fourth Amendment protection due to the vast amount of private information they contain. Well, in his case, it had a lot of illegal stuff on it, for sure, didn't it? Burden on the moving party. The moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. Norman v. State, 379, Southern 2D, 643, 646 through 647. So, all right. Statement of facts. 1. On February 26, 2024, at approximately 2,000 hours, Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. 2. On February 27, 2024, Detective Francis Hunt identified inconsistencies in statements provided by Mrs. Soto and Mr. Sterns. 3. Detective Maria Tagler of the Orange County Sheriff's Office was assigned as lead investigator. 4. On February 27, 2024, at approximately 1600 hours, Detective Tagler, accompanied by Detective Acosta, contacted Mr. Sterns at his residence. 5. The detective's interactions with Mr. Sterns were audio recorded and captured the exchanges between law enforcement and Mr. Sterns. 6. Mr. Sterns' residence is located at 4012 Santa Maria Drive, Kissimmee, Florida, 34746. Not anymore. He's living in Osceola County Jail on Simpson Road. But I digress. 7. Detective Tagler sought limited access to Mr. Sterns' cell phone, specifically requesting only to check his Google login status by asking, "Is it okay if I go into your settings real quick? I just want to see if you're logged in onto your Google." 8. Mr. Sterns responded, "Yeah," to this specific and limited request. 9. After exceeding the scope of this limited consent, Detective Tagler unilaterally announced, "I'm going to hold onto your phone, and I'll give it back to you when we're done." 10. Mr. Sterns expressed explicit concern about maintaining contact with his father through that phone. 11. Detective Tagler dismissed Mr. Sterns' concerns by stating they could call Ms. Soto's cell phone instead. 12. Mr. Sterns was given no choice regarding the seizure of his phone. 13. No consent was sought for the seizure of the phone. Wrong. 14. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. Well, they weren't. It wasn't needed. He gave them consent. They asked, "Do we need a warrant?" It's fine. 15. The detectives did not present Mr. Sterns with a written consent form for the seizure. 16. The detectives did not advise Mr. Sterns of his right to refuse consent. 17. The detectives did not provide Mr. Sterns with any documentation regarding the seizure of his phone. 18. The detectives did not document any exigent circumstances justifying the warrantless seizure. Now, I do wonder if they should have covered their asses and gotten one. That I do wonder, but that's a good question for sure. 19. On February 28, 2024, at approximately 0130 hours, detectives again contacted Mr. Sterns. 20. The second contact occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. 21. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, "I told you I was going to hold on to it and that we would like to download your phone, right?" 22. The detectives presented Mr. Sterns with an ultimatum. "Is this something I have your consent to do, or do I need to get a search warrant for your phone?" That's not an ultimatum. They were asking him a question. 23. At the time of the midnight interaction, Mr. Sterns had been detained outside in 50 to 60 degree temperatures. Aw, the poor guy. Was he cold? 24. Mr. Sterns was wearing only flip-flops, khaki pants, and a thin hoodie. Again, I have to cry for him. Yeah. Mr. Sterns had not eaten all day prior to the incident. I don't believe that at all. 26. Mr. Sterns was not allowed to return to Miss Soto's vehicle, which was heated despite the cold weather conditions. Yeah, they want to make a big deal because, was little Stephan cold? Was he cold? How horrible. I mean, I think he's a big guy and I think he can handle it. Remember how much he complained about the temperature when they were transferring him Orange County to Osceola County, too. They had me sleep on the cold floor. I didn't even get a blanket. 27. Earlier that night, Mr. Sterns had taken Ativan, a prescription medication to manage his panic attacks. He had panic attacks because he had just killed Madeline and dumped her in a wooded area. Yeah. 28. Mr. Sterns clarified to the authorities that he had taken the tranquilizers to help him sleep as he had been struggling with insomnia. 29. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. 30. Ativan is known to cause drowsiness, sedation, and impaired alertness. 31. Mr. Sterns describes the effects of Ativan to law enforcement, stating, "This is why I missed your calls. I'm sorry. Took an Ativan and conked out for a few hours." Unquote. I think that was earlier in the day. I do wonder how long it stays in your system. That's a good question. 32. At approximately 0240 hours on February 28, 2024, Mr. Sterns' phone was taken to the Orange County Sheriff's Office Digital Forensics Unit. Legal argument. A. The warrantless seizure of Mr. Sterns' cell phone was unconstitutional. The Fourth Amendment protects against unreasonable seizures of property, even when no search has taken place. United States versus Place. A seizure of property occurs when there is some meaningful interference with an individual's possessory interest in that property. United States versus Jacobson. The instant matter presents precisely such a meaningful inference as Detective Tagler unilaterally seized and retained Mr. Sterns' cell phone for over 9 hours without consent or probable cause. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitution is coextensive with the Fourth Amendment jurisprudence. State versus Hernandez. While law enforcement may temporarily seize property to prevent the destruction of evidence while seeking a warrant, such seizures must be properly limited in scope. Place 462, United States. The United States Supreme Court has emphasized that courts must consider the length of the detention in determining whether a seizure is reasonable. The Supreme Court held in place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed reasonable in place. The Florida Supreme Court's analysis in Golphin v. State further illuminates why the seizure here was unconstitutional. Golphin v. State. In Golphin, the court examined whether retention of identification during brief warrants check constituted a seizure, emphasizing that not all encounters between law enforcement and individual citizens constitute seizures, but rather courts must examine the totality of circumstances to determine if there was meaningful interference with possessory interests. Unlike Golphin, where officers merely retain identification briefly during a consensual encounter, Detective Tagler effected a full seizure by unilaterally announcing she was taking possession of the phone without seeking consent, retaining it for over 9 hours, and completely depriving Mr. Sterns of his ability to communicate with family members. Yeah. The extended duration and complete deprivation of Mr. Sterns' possessory interest in his phone demonstrates why this case falls squarely within Place's holding that even brief investigative detentions of property must be properly limited in scope and duration. Detective Tagler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure. Instead, Detective Tagler retained the phone for over 9 hours without providing any indication of when or how it would be returned, far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. The length of the detention alone precludes any argument that this was properly limited investigative detention under Place and its progeny. 1. The initial seizure exceeded the scope of any purported consent. While consent provides an exception to the Fourth Amendment's warrant requirement, such consent is strictly circumscribed by its express scope and circumstances. Florida versus GMO. The United States Supreme Court has established the standard for measuring scope of consent is one of objective reasonableness. Specifically, what would the typical reasonable person have understood by the exchange between the officer and the suspect? This objective standard protects against law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. Florida courts have consistently enforced strict limitations on the scope of consent, recognizing that permission granted for one limited purpose cannot justly justify broader government intrusion. In Appellate v. State, the 5th District Court of Appeal held that consent to enter a home to check on well-being did not authorize a full search of the premises. Appellate v. State. Similarly, in State v. Wells, the Florida Supreme Court determined that consent to search a car trunk did not exceed to closed containers within that trunk. State v. Wells. These decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. In the instant case, Mr. Sterns provided extremely limited consent for Detective Tagler to go in your settings real quick, solely to see if you're logged onto your Google. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5-hour retention of the device. Detective Tagler's unilateral announcement that she was going to hold onto your phone and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Sterns' limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Appellate and Wells. Just as consent to look at a trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. They're trying really hard, but I think that they have this covered. Do I think it's going to take some real good arguments from the state? Yes, but I don't think that, personally, my opinion, and I want to hear you guys' opinions as always, I don't think they're going to win this one. But who knows? The unreasonableness of interpreting such limited consent to authorize extended seizure is particularly apparent given the Supreme Court's emphasis in place that even brief investigative detentions of personal property must be strictly limited in scope and duration. When Detective Tagler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed, rendering the extended seizure unconstitutional under both consent and general Fourth Amendment principles. No extended circumstances justified the extended seizure. While law enforcement may conduct a warrantless seizure when exigent circumstances exist, such circumstances are few in number and carefully delineated. Welsh versus Wisconsin. The state bears the burden of demonstrating that the procurement of a warrant was not feasible because the exigencies of the situation made that course imperative. Coolidge versus New Hampshire. None of the recognized exigent circumstances existed here. First, there was no hot pursuit of a fleeing suspect that would justify the warrantless seizure. See United States versus Santana. Mr. Sterns was at his residence and fully cooperative with law enforcement when Detective Tagler seized his phone. He made no attempt to flee or evade the officers. Second, there was no imminent destruction of evidence. See Kentucky v. King. Detective Tagler articulated no specific facts suggesting Mr. Sterns was attempting to or about to delete data from his phone. Well, we find out later he was definitely trying. Well, remember he said he did an accidental, quote-unquote, accidental factory reset. So I think that's going to be an argument from the state. Indeed, the phone had already been factory reset, there you go, prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent destruction of evidence. They're saying they could still get it, they just needed their warrant. See, this is their argument basically is, y'all didn't get a warrant. The mere possibility that additional digital evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. Riley versus California. Whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened. My question is, even if you verbally consent, and if you're out there and you know the answer, even if you verbally consent, you tell the cop, which is what he did, he told Detective Tagler, fine, that she could do it. Does law enforcement, do they need a warrant and a consent or a consent form signed anyway? I think it helps, but is it necessary? Third, no emergency aid circumstances existed. See Brigham City versus Stewart. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. Yeah, I'm sure they will. See Brigham City versus Stewart. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable basis to believe that an emergency exists requiring immediate action to prevent imminent harm. Missouri versus McNeely. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5-hour warrantless seizure. So, would they have been okay with like a couple hours? You gotta wonder. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 2,000 hours, 8 p.m. on February 26th, yet Detective Tagler did not seize the phone until 1600 hours on February 27th, some 20 hours later. This significant delay undermines any argument that immediate warrantless seizure was imperative. See Mincy versus Arizona. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. This part I might actually agree with. Although, hopefully it doesn't get them, this is all thrown out. Even assuming arguendo that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter without an accompanying intent to either arrest or search. State versus Fultz. Detective Tagler's own statements reveal the investigatory purpose behind the seizure, as she explicitly told Mr. Sterns, "I told you I was going to hold onto it and that we would like to download your phone," right? Demonstrating from the outset that her intent was to conduct a forensic search rather than address any emergency. Once the phone was secured, any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tagler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Instead, law enforcement simply held it for over 9 hours before seeking consent for a forensic examination. This behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under the emergency exception, the person making the entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within. United States versus Moss. This objectively reasonable belief must be based on specific articulable facts and reasonable inferences that could have been drawn therefrom. Seymour versus City of Gaithersburg. Here, Detective Tagler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent immediate harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an objectively reasonable belief that an emergency requiring immediate warrantless seizure of the phone. Fourth, there were no community caretaking circumstances requiring immediate action. See Katie versus Domowski. The phone itself posed no danger to the public, and its seizure clearly investigatory rather than for community protection purposes. Fifth, there were no exigent circumstances related to officer safety. See Maryland versus Bew. The phone posed no threat to officer safety, and Mr. Sterns displayed no aggressive or threatening behavior that would justify an immediate seizure. Instead of demonstrating any recognized exigency, the record shows that Detective Tagler had ample time and opportunity to obtain a warrant through the Ninth Circuit's established emergency duty judge system under Administrative Order 7-8411, which has a mandated 24/7 emergency duty judge protocol for nearly 40 years, specifically to handle after-hours warrants. The United States Supreme Court has emphasized that the availability of a telephonic warrant is relevant to the exigency analysis. See Missouri versus McNeely. Here, Detective Tagler's complete failure to pursue these readily available warrant procedures during the 9.5-hour seizure, during which Mr. Sterns was completely deprived of his ability to communicate with family members or access any of the phone's essential functions, is particularly egregious and negates any claim of exigent circumstances. Despite the well-established warrant system and the availability of an emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this resource, further demonstrating the unconstitutional nature of their actions. I do think it wasn't for an emergency. That's about so far the only thing I agree with. 3. All evidence derived from the unlawful seizure must be suppressed. When consent is obtained after illegal police activity, such as an unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. Norman versus State. The consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of legality sufficient to dissipate the taint of prior official illegal action. From the fruit of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. Wong Sung versus United States. The relevant inquiry is whether the evidence was obtained by exploitation of the initial illegality or by means sufficiently distinguishable to be purged of the primary taint. The Florida Supreme Court has consistently held the evidence discovered by exploiting previous illegal conduct is inadmissible. Craig versus State. Here, there was no break in the chain of illegality between the unconstitutional seizure and the subsequent searches of the phone. The extended deprivation of Mr. Sterns' phone created coercive circumstances that led to midnight consent for its forensic examination. Any purported consent was implicitly intertwined with and a direct product of the illegal seizure. The court warrant, the Google warrant, and all derivative evidence were direct products of the initial unlawful seizure, as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through the exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom, must be suppressed as fruits of the poisonous tree. Conclusion. Detective Tagler's warrantless seizure of Mr. Sterns' cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. The 9.5-hour deprivation of an essential communications device without consent or extrinsic circumstances violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations. Wherefore, the defendant respectively requests this honorable court, 1, set this matter for evidentiary hearing pursuant to Florida A. Crim 3.190, 2, suppress all evidence obtained from and derived through the unlawful seizure of his cell phone, and 3, grant such other relief as this court deems just and proper. And it's signed by his public defender, Melissa Vickers. There you go. Yeah. That's a lot. It's a lot. So I'm not going to actually go through. I didn't realize how long that was going to take. See, right here, guys, look. There is, I don't know if this has been updated, but there's another 26 pages here. And then there's 22 pages for the motion for the Google search warrant. So, to keep this video from being too long, I'm going to stop it right here. And you guys can let me know if the longer videos are okay, or if you prefer kind of doing it in smaller bites. You know, I think smaller bites are sometimes a little better. So what do you guys think? Just from that 14-page, we all know there's a lot of legalese, a lot of big words and all that, which they like to throw in there. But I think they're trying really hard, but I don't think it's gonna pass. I'm really hoping it's not. I think the consent was there, as I said, and I mean, obviously it wasn't an emergency. I do agree with that particular portion of that motion, but he consented because he was taking Ativan. He even said at one point that he wasn't on any drugs. So I'll have to find that bite too. He mentioned he was on an Ativan, and then he also, of course, said that he wasn't taking anything. So, yeah, Sterns kind of likes to play the back and forth game, which is pretty par for the course with these criminals and monsters that we get to see. So, but let me know your thoughts, as always, in the comments. What do you guys think of this whole trying to suppress the cell phone information, which is where they got the majority of the photos, and then they got the Google, you know, all that stuff. It is really important evidence, and I personally don't think the motion's gonna fly. But again, I do think that they could have covered their ass by getting a signed consent and or warrant, but was that really necessary? That's the question. All right, guys, I hope you have a great rest of the day, and most of all, stay safe.